2026, thousands of people in California could be pushed into deportation proceedings without ever being caught at the border. And here's the part that sounds almost unreal. Some cases begin after a traffic stop, a routine background check, or a paperwork mistake that looks small on the surface. Sounds like a rumor, right? But immigration attorneys have been warning that the rules around who gets flagged, how fast cases move, and which records get shared are shifting. And that shift can turn an ordinary day into a legal nightmare. Most people think deportation only targets dangerous criminals or new arrivals. But 2026 is stirring up a different fear. People who've lived here for years, who work, pay rent, and keep their heads down, suddenly finding themselves on a list they didn't know existed. And the scariest part? You might not even realize you're at risk until the system is already moving. So in this video, we're breaking down 10 major changes tied to California's 2026 policies. What's real, what's misunderstood, and who is actually getting caught in the net. Stay with me because one of these changes hits a group that almost everyone assumes is safe, and it's the one most people never see coming. Number 1. Expanded cooperation in certain criminal cases. One of the most talked about changes in 2026 is California's expanded cooperation in certain criminal cases. And this is where things start to surprise people. For years, California has been known as a sanctuary state, limiting how much local law enforcement works with federal immigration authorities. But under updated guidelines, cooperation is now more clearly defined, and in some situations expanded, when it comes to individuals charged with or convicted of specific serious or violent felonies. That means if someone is arrested for crimes categorized as high risk to public safety, local agencies may now share information with federal immigration officials more quickly than before. What's different in 2026 isn't that cooperation suddenly exists, it's the clarity and speed of it. The revised framework narrows down which offenses trigger notification and shortens the time window for communication between local jails and federal authorities. In practical terms, this can reduce the gap between local custody and possible immigration review. Legal experts point out that this doesn't apply to minor infractions or routine stops alone, but when combined with a qualifying criminal charge, the consequences can escalate fast. For someone already navigating the criminal justice system, immigration status can suddenly become part of the equation. Here's where it becomes personal. If you or someone you know is a non-citizen facing serious criminal allegations, understanding how these expanded cooperation rules work is critical. A criminal case is no longer just about fines, probation, or jail time. It can now carry immigration consequences that move quickly and quietly behind the scenes. That's why attorneys are emphasizing early legal advice and awareness of rights. The key takeaway? In 2026, certain criminal charges don't just stay in state court, they may open a direct line to federal immigration review, and that shift is reshaping how these cases unfold across California. Number 2. Fast-track deportation for repeat border crossings. Another major shift in 2026 focuses on individuals with repeat border crossing violations, and this is where enforcement timelines are getting noticeably faster. In previous years, immigration cases involving prior removals or repeated unauthorized entries often moved slowly due to court backlogs and procedural delays. But under updated coordination policies, data sharing between local detention facilities and federal immigration agencies has become more streamlined. That means if someone has a prior removal order and is taken into custody again, their case can now move into expedited processing much more quickly than before. What makes this change significant is the emphasis on repeat violations rather than first-time encounters. Authorities are prioritizing individuals who have previously been deported and later re-entered without authorization. With improved digital record matching and fingerprint database integration, identifying prior removal history now happens almost instantly. Legal analysts note that this reduces the window of uncertainty that once existed between arrest and immigration review. In some cases, individuals may be transferred into federal custody sooner, limiting the time available to prepare legal defenses or request certain forms of relief. For viewers, the key point is understanding how past immigration history can dramatically influence present circumstances. A prior deportation order doesn't just stay in the past. In 2026, it can trigger accelerated consequences if another encounter with law enforcement occurs. That's why immigration attorneys stress the importance of knowing your legal record and seeking professional guidance if you have a complex history. The system is becoming more automated and interconnected, and when technology speeds things up, the margin for error or delay becomes much smaller. Number 3. Stricter review of public benefit fraud cases. The third change raising eyebrows in 2026 involves stricter review of public benefit fraud cases, and this one is catching many people off guard. California continues to provide access to certain public programs regardless of immigration status. But when authorities detect intentional fraud tied to benefits, new reporting requirements can now trigger closer immigration scrutiny. This doesn't mean using public benefits automatically leads to deportation. That's a common misconception. The focus here is specifically on proven cases of fraud that cross defined financial thresholds or involve false identity documentation. What's new is the level of mandatory reporting and interagency coordination when fraud is confirmed. Under updated guidelines, certain agencies are required to notify appropriate authorities once an investigation reaches a specific stage. In practical terms, if someone is convicted of significant public assistance fraud, that criminal finding could now be more directly visible during immigration status reviews. Legal experts emphasize that honest mistakes or paperwork errors are not the same as criminal fraud, but when prosecutors pursue and prove intentional deception, immigration consequences can follow more swiftly than before. This is where awareness becomes critical. Many families rely on public programs legally, and fear spreads quickly when policy changes are misunderstood. The important takeaway is simple. Eligibility matters, documentation matters, and intent matters. If you qualify for assistance, use it properly and keep records organized. But if there are questions about your case, especially involving allegations of fraud, seeking legal advice early can make a major difference. In 2026, certain criminal findings don't just end with restitution or penalties. They can open the door to a broader review of immigration status that moves faster than many expect. Number 4. Changes to worksite enforcement coordination. Number 4 shifts the spotlight to the workplace, and for many people this one feels uncomfortably close to home. In 2026, California updated how it coordinates with federal authorities during certain worksite enforcement investigations, especially in cases involving repeated employer violations. While the state still maintains protections that limit surprise federal raids without proper notice, new compliance rules now require more structured reporting when businesses are found to be knowingly hiring unauthorized workers or repeatedly failing employment verification standards. That means when serious violations are confirmed, information may move faster between agencies. What's different isn't random workplace sweeps, it's the increased focus on employer accountability and documentation accuracy. Businesses found ignoring federal verification systems or falsifying records face steeper penalties, and those investigations can sometimes expose workers whose paperwork doesn't match federal databases. With improved digital cross-check systems, discrepancies that once took weeks to uncover can now surface almost instantly. Legal analysts stress that the primary target is non-compliant employers, but workers can still feel the impact if their documents are flagged during a broader investigation. So what does this mean for everyday employees? It means understanding your employment paperwork matters more than ever. Make sure your records are accurate, your documents are legitimate, and your information matches across applications. A simple mismatch, like a misspelled name or outdated status update, can now trigger additional review. In 2026, the workplace isn't just about earning a paycheck. It can become a checkpoint where documentation, compliance, and immigration status intersect in ways many people never imagined. Number 5. Temporary Protected Status, TPS, reassessment triggers. Number 5 is creating quiet anxiety among communities who believe their protection was locked in. In 2026, new verification procedures tied to Temporary Protected Status, TPS, have introduced stricter reassessment triggers when documentation deadlines are missed or identity records don't match federal databases. TPS is designed to protect individuals from countries facing war, natural disasters, or extraordinary crises. But here's the part many people overlook. TPS is temporary by design, and it requires ongoing re-registration and accurate paperwork to maintain protection. What's changing now is the speed and automation of verification checks. Digital cross-referencing systems are being used more aggressively to flag expired work permits, missed renewal filings, or inconsistent identity information. In the past, delays sometimes went unnoticed for months due to processing backlogs. In 2026, those gaps are harder to hide. If a TPS renewal isn't filed correctly or on time, it can create a lapse in protection, and that lapse may trigger further immigration review. Experts emphasize that this does not mean mass cancellation of TPS, but it does mean compliance deadlines matter more than ever. For individuals relying on TPS, the key word is proactive. Mark renewal dates early, keep copies of every submission, and confirm receipt notices are properly issued. Even small administrative errors can now have larger consequences in a faster, more connected system. TPS still offers protection, but in 2026, maintaining it requires careful attention to detail. When your legal safety net depends on paperwork, staying organized isn't optional, it's essential. If this video opened your eyes even a little, don't stay silent. Drop a comment with one word, concerned or prepared. Let's see where our community stands. And before you leave, watch our previous video breaking down federal immigration powers, because it connects directly to what we discussed today. We spend hours researching and simplifying these complex laws so you don't have to, so please support our work by subscribing. It's just one click, but it helps us keep bringing you clear, fact-based updates. Number 6. Expanded detention criteria for certain charges. Number 6 is where things start to feel especially unsettling for many families. In 2026, updated guidelines expanded how certain criminal charges are evaluated for detention and immigration review, even when those charges are not classified as major felonies. Previously, cooperation thresholds focused heavily on serious or violent crimes. But now, some additional categories, particularly repeat offenses or crimes labeled as threats to public safety, may trigger closer scrutiny. That doesn't mean every misdemeanor leads to deportation. But it does mean the definition of what raises concern has become broader in specific contexts. What's changed is the interpretation of public safety risk. Under the updated framework, patterns of repeat offenses, even lower-level ones, can factor into decisions about detention notifications. With improved digital record systems, law enforcement agencies can quickly identify prior charges across counties. In practical terms, someone with multiple offenses over time may now face immigration review faster than they would have just a few years ago. Legal analysts stress that each case is still evaluated individually, but the margin for being overlooked has shrunk significantly. This is why awareness matters more than ever. A charge that once seemed minor or handled can resurface in a more connected system. If you are not a U.S. citizen, even resolving a case with probation or fines doesn't automatically erase potential immigration implications. The key takeaway here is simple. Criminal history and immigration status are increasingly linked through faster data systems. In 2026, small patterns can carry bigger weight, and understanding that connection could make all the difference when navigating the legal system. Number 7. Digital immigration status verification integration. Number 7 may not sound dramatic at first, but it could be one of the most powerful shifts happening in 2026. California is expanding the integration of digital immigration status verification systems, allowing certain state databases to cross-check information more efficiently with federal records. In simple terms, technology is doing what paperwork delays used to slow down. Instead of waiting weeks for manual confirmation, status information can now be reviewed in real time during specific government processes. What does that mean in everyday life? It means that when someone applies for a license, renews certain permits, or goes through background checks tied to regulated activities, databases may automatically verify immigration status through interconnected systems. This isn't a brand new concept. Verification tools have existed for years, but the difference now is speed and synchronization. Overstayed visas, expired documentation, or mismatched identification numbers can be flagged almost instantly. And when systems are automated, there's less room for delays that once gave individuals time to correct issues quietly. The key takeaway here is accuracy. In a world where records talk to each other faster than ever, even small inconsistencies can trigger follow-up reviews. A misspelled name, outdated address, or expired document might not have caused immediate problems in the past. In 2026, those gaps can surface quickly. Technology is becoming a silent gatekeeper, and for many people, understanding how digital verification works is just as important as understanding the laws themselves. Number 8. Post-release transfer policy adjustments. Number 8 focuses on what happens after someone is released from local custody, and this is where timing becomes critical. In 2026, California updated certain post-release transfer procedures, particularly in cases where individuals meet defined criteria for immigration notification. While the state still limits broad cooperation under sanctuary policies, specific qualifying cases may now involve shorter notification windows. That means when someone finishes serving local time for a qualifying offense, federal authorities could be notified within a more streamlined timeframe than before. Previously, there were situations where administrative delays created a gap between local release and any potential federal action. In 2026, that gap may be reduced in defined circumstances. Improved coordination systems allow custody status updates to move faster between agencies when required by law. Legal experts emphasize that this does not apply to every arrest or release, only to cases that meet specific legal thresholds. However, for those who do fall within those categories, the transition from local custody to federal review can now happen more quickly and with fewer procedural pauses. Why does this matter? Because timing can determine opportunity. A longer release window once gave individuals time to consult attorneys, notify family members, or prepare documentation. With shorter transfer periods in qualifying cases, preparation becomes even more important ahead of time, not after release. In 2026, understanding whether a case falls into a category that triggers notification could make a major difference. When policies move faster, the ability to plan ahead becomes one of the most valuable protections a person can have. Number 9. Increased funding for immigration court coordination. Number 9 doesn't sound dramatic at first. More funding rarely does, but this one could quietly change how fast cases move. In 2026, additional resources have been directed toward improving coordination between local facilities and immigration courts, with the goal of reducing massive case backlogs. For years, delays meant some deportation proceedings stretched on for months, sometimes even years. Now, with upgraded scheduling systems, additional administrative staff, and more structured communication channels, certain hearings may be scheduled more quickly than before. At first glance, faster court dates might seem like a good thing. After all, who wants endless waiting? But here's the twist: speed can cut both ways. A quicker hearing timeline means individuals may have less time to gather documents, secure legal representation, or prepare a strong defense. Legal experts are advising non-citizens to treat any notice from immigration authorities with urgency. The days of assuming it will probably take forever may not apply in the same way under improved coordination systems. The key takeaway is preparation. If someone receives notice of immigration proceedings, acting immediately becomes even more critical in 2026. Faster coordination can mean faster outcomes, whether positive or negative. And when court calendars move at a quicker pace, being organized, informed, and legally prepared isn't just helpful, it can be the difference between relief and removal. In a system that once moved slowly, acceleration changes the strategy entirely. Number 10. Expanded review of visa overstays. And now we arrive at number 10, the one many experts say could affect more people than anyone expected. In 2026, enforcement focus is increasingly shifting toward visa overstays, not just unauthorized border crossings. Here's the reality: a significant portion of undocumented individuals originally entered the country legally with a visa and simply remained after it expired. With upgraded data sharing systems connecting travel records, employment filings, and certain state databases, identifying overstays has become far more precise and automated. What makes this change stand out is the emphasis on data matching technology. Entry and exit records, work authorization timelines, and identification databases can now be cross-referenced faster than ever. In the past, overstays were harder to track consistently due to incomplete exit data or processing delays. In 2026, digital integration reduces those blind spots. That means someone who overstayed a student visa, tourist visa, or temporary work visa could face increased scrutiny if their records surface during background checks or administrative reviews. This shift surprises many people because visa holders often don't see themselves in the same category as unauthorized entrants. But once a visa expires without renewal or adjustment of status, the legal protection attached to it disappears. The key lesson here is simple but powerful: legal entry does not guarantee permanent legal stay. If a visa is approaching expiration, exploring renewal, extension, or status adjustment options early is crucial. In a system powered by faster technology and tighter coordination, overstays are no longer slipping quietly through the cracks. They're being flagged in ways that are far more systematic than before. As you can see, California's 2026 deportation-related updates aren't about one single dramatic law. They're about layers of changes that, when combined, create a system that moves faster, shares more data, and leaves less room for delay. From expanded cooperation in certain criminal cases to stricter documentation checks, digital verification systems, and increased focus on visa overstays, the common theme is clear: speed, coordination, and automation. And when systems become faster and more connected, small issues can grow into serious consequences much more quickly than before. But here's what's important to remember: not every change applies to everyone. Many of these updates target specific categories: repeat offenses, confirmed fraud cases, or expired documentation. The danger often comes from misunderstanding the details or assuming it won't affect me. Immigration law has always been complex, but in 2026, complexity is amplified by technology. Records talk to each other. Deadlines matter more. Past history doesn't simply disappear. And for non-citizens, being proactive is no longer optional, it's essential. If this breakdown helped you better understand what's really happening behind the headlines, make sure to like this video, subscribe to the channel, and turn on notifications so you don't miss future updates. Drop a comment below. Do you think these changes improve public safety, or do they create more uncertainty? I'd love to hear your perspective. And remember, this video is for informational purposes only and should not replace professional legal advice. If you're facing immigration concerns, consult a qualified attorney. Stay informed, stay prepared, and I'll see you in the next video.